May I please, my lord? Lordship, I beg to mention hearing item number 16. This is a consensus prayer, Lordship. If this matter can be listed after 2 weeks, my lord. Hearing item 16, my lord.
Of the parties, let's list the matter after the summer vacation for you.
I'm deeply obliged, my lord.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next date.
Obliged.
May I please, your lordship? I beg to mention item number 6. Kindly, this matter may be listed after the vacation.
6.
Yeah, please, my lady. There's an urgency in this matter. The issue relates to the petitioner has challenged the special recruitment of COVID appointee doctors. And since the matter is pending, during the pendency of the writ petitions, the department has
So this is item 4, 5.
yes,
They are clubbed.
all club. Now, during the pendency of the present bunch of writ petitions, the state government had already advertised 30 posts of medical officers. Their written exams are to be held this week. So there is an urgency on this matter. So let it be on 14th of July,
Opening.
because that is the date of reopening. Because of the pendency,
Yes, lordship.
it is creating a lot of complication in the dilemma for the parties because of the exam. In any case, the case should be concluded before the result is declared.
Yes, yes, it should be. Learned counsel for the, you are in petitioner.
No, respondent number 4 to 12 in item number 6.
Respondent 4 to 12 in item number 6. Respondent number 4 to 12 has prayed for listing the matter after the summer vacations. Learned senior counsel, Mr. Takamasa, appearing for the petitioners in which case? In
I'm appearing in one case,
WPC
307, and respondent in another one.
307/2024 has submitted that there is some urgency in this matter. As the government has already advertised 30 posts.
Yes, Lord.
30 posts
Of medical
a
officer.
medical officer. And therefore the matter needs to be disposed of expeditiously. Accordingly, list the matter on 14th. On the opening date 14 July.
Kindly make it clear that the endeavor can be made for disposal on
It's
the
a
next.
fixed item. It's a
Oh,
fixed
please.
item.
Much obliged.
Much obliged.
No, please, my lordship.
Yes.
I beg to mention item number 10.
Hmm.
Here, the approval order is out, but the appointment order is yet to be issued. So I pray that this matter may be listed after the summer vacation.
You are for the respondent?
Yes.
Learned, counsel Vishupri appearing for respondents has prayed for listing the matter after the summer vacations as the approval order is due to be issued.
It's already issued, but
already
the
issued.
appointment order,
It's already issued, but the appointment order is still awaited.
Mm.
So prayers allowed. Petitioner,
they are not around.
petitioner is absent. This is the matter after the summer vacations.
Much.
Yeah, please, my lady.
Yes.
I'd like to mention item 29, hearing item.
Hmm.
On behalf of Senior Advocate Moem Chen. I pray that the matter may be listed on Friday. He's having some personal difficulties today. 19.
Item 29 in the
Supplementary
supplement
hearing.
list. Action has been made on behalf of Mr. Moa Imjan, Learned Senior Government Advocate, who has some personal difficulties today. So prayers made for listing the matter after vacation.
On Friday.
Oh,
if
on
possible,
Friday.
yes.
Friday. Thursday, how about Thursday?
Your Lordship,
We'll try otherwise after vacation
Your Lordship.
on Thursday. Counsel for the petitioners present. Yes. On Thursday.
I'd also like to mention item 18 on behalf of Inaholi Government Advocate. To pray that the matter may 18. 18. Pray that the matter may be listed after the vacation.
Prayers made on behalf of Miss Inaholi Government Advocate for listing the matter after the summer vacation as she has some difficulties today. Learning counsel for the petitioners present. Stop prayers allowed list after summer vacation.
Also have a similar prayer for item 21 and 22 on behalf of Inaholi.
Inaholi.
Yes.
21, 22 also said on behalf of Inaholi after summer
Your
vacation.
Lordship, in this case, I'm appealing for the petitioner. Just an urgency in this case. So can it be taken up on 17? Immediately after the vacation.
Fix it on 17 July. 21, item 21.
21, 22, 21, 22.
Analogous.
Okay, okay,
Another-
okay. Item 21 and 22. 17 July.
Obliged.
Please, Lordship, I beg to mention hearing item number 17. I'm for the petitioner. Let this matter may be listed after vacation. I've taken the consent of the other parties.
Counsel for the petitioner as warning, with the consent of the respondents submitted, has prayed for listing the matter after the summer vacation. Praise allowed list of the summer vacations.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 27, lordship. Lordship, this matter has become infructuous, lordship.
27.
Contempt petition.
Supplementary list.
Yes, in the supplement, the writ appeal filed by the stake has already been allowed, so
So the contempt is.
no more survives.
स्लाइड नहीं करते हो बोला ये स्लाइड प्रोटेक्टिव वन
Then it counsel for the petitioner.
व्हाट इज स्लाइड है तो
In practice, and accordingly, the matter may be disposed of. So, so for the respondents, has no objections, the matter is disposed of on being infructuous.
My lady, my name may be reflected.
Yes, yes, then
Yes.
also we should grant this, appearing for the respondents.
Much obliged.
Much obliged, lordship.
May I please, Your Lordship, I'd like to mention item number 15 hearing. Let the matter come up after vacation on behalf of City Jamir. For respond number 1 and for
Okay. We are mentioning on behalf of
City Jamir.
Jamil. Learned counsel, for the respondent number 1 has prayed for listing the matter after the summer vacation. So, learned counsel for the petitioners present and has no objections, list after summer vacation for hearing.
Keep the play.
May it please your ladyship, I beg to mention hearing item number 30. I'm appearing on behalf of my senior and long-term lordship. If the matter
Hearing
can be
item-
come up after summer vacation.
Which one, I think
Hearing item number 30,
30,
yes.
30 supplementary list. My mention is made on behalf of who? You're mentioning on behalf of?
And Longkumar,
Item number 30.
yes.
His name is not there. Mohammed Jamir M. Jamal. Government Advocate. He's for respondent,
Number 3,
respondent number 3. Learned counsel appearing for respondent number 3 has prayed for listing the matter after the summer vacation.
yes.
Learned counsel for the petitioners present, no objections. List the matter after summer vacation for hearing. Yes.
I'm sorry. May I mention item number 12 minutes?
Item 12, yes.
12 minutes. The
Yes.
matter is listed today, but I want to do it physically because I'll be showing some documents to the Honorable Court. So, my lords, I have another matter before my lords on 25th of June.
When?
25th of June, 25th of this month.
8,
Yeah, 5 minutes.
2, 5.
Yeah,
Okay.
so if my lords can have it on the same day, both matters I can do physically.
On the
And
prayer.
my associate, Mr. Lotha, is there in the court.
25th of July, Lordship.
25th
July, my apology, I'm extremely sorry.
25th
25th of July minutes.
July or June?
July
July.
minutes.
July, 25th of July. Okay. List the matter on 25th July.
For final hearing, Lordship.
It's for orders. It's in the orders column. For orders as sprayed by the Rent Council for the petition. So, yes.
Grateful minutes.
Yes.
Obliged.
Obliged, Lords.
May bless your Lordship. Lordship, I like to mention item 14 in the order column. Lordship, in this case, I have received instruction to appear on behalf of the respondent 1 to 4.
Item 14.
Yes,
Rent Council.
I'm yet to file the power
Oh, it- So how
3
much
weeks.
time?
3
3
weeks
weeks. Rent
to
Council,
file
Mr. Apomana
written
has,
objection as well as the filing of power
submitted that he has received instructions to appear on behalf of respondent
1
number
to 4.
1 to 4 and
Those are the
accordingly
agreements.
prays for time to file his vakalat number as well as the affidavit in opposition. So advice prayers allowed list after 3 weeks.
Obliged, Lord.
For motion from the supplementary cost list, item number 23.
May it please your Lordship.
Yes.
My lord, this is a petition under section 4, 528, my lord.
Washing.
My lord, yes, my lord. In fact, the big background of the case is like this, my lord. In the year 2012, my lord, there was a FIR was filed before the SP crime branch, my lord, with regard to, my lord, some complaint with regard to the, my lord, National Rural Health Mission works allotted,
With regard to,
National Rural Health Mission work.
okay, NHM.
Yes, my lord, that some orders were there placed by the National Rural Health Mission. My lord, as against that, my lord, FIR was filed, leveling certain allegations. And my lord, at the same time, my lord, the activist, social activist, my lord, filed a PIL in the High Court in Kohima, my lord, which your lordship will find at page 257. His lordship got it, my lord.
Yes.
257, running page, my lord.
What was the PIL for?
May I read, my lord?
Yes.
In fact, my lord, immediately after, my lord, the FIR was filed, my lord, the police headquarters, my lord, they, my lord, fixed a SIT, appointed SIT, and also, my lord, the officer, investigating officer was also appointed. And my lord, they submitted report, my lord, and the High Court, my lord, lordship may kindly come to 257. Heard so and so. Second para, lordship may kindly see. By this petition, the petitioner has come up with the 3 prayer that is directing the respondent to register forth with a criminal case on the strength of FIR dated 2 June 2012, directing the respondents calling for an explanation as to why they failed to register a case in connection with the FIR dated 2nd June 2012. And lastly, praying for a direction to the CBI inquiry into the scheme at National Rural Health Mission, Nagaland. It is the submission of Learned Council for the petitioner that the FIR was lost on 2nd June 2012, wherein serious allegations were made on the rampant corruption within the National Rural Health Mission, Nagaland. As many as 11 allegations were made. The respondents, instead of taking prompt action, were instead sleeping over the matter being agreed by the action of the respondent, the present petition was filed by the present petitioner seeking the aforesaid direction. Then Lordship may kindly see, Ms. So-and-so landed decision advocate in Nagaland submitted the allegations made in the writ petition is not correct. The respondents had initiated prompt action immediately on the receipt of FIR dated 2nd June 2012. A crime police station GD entry number so-and-so registered, which also reflected in the affidavit in the position of an XFC and to the petition. Thereafter, on the basis of FIR filed by the petitioner, on Srimati so-and-so, SP's equity was appointed to conduct the preliminary inquiry based on the allegations made in the FIR by another memorandum dated 2nd April 2013. The matter was re-endorsed to SP crime to act in inquiry officer and was directed to submit written report within 45 days. The next to the preliminary inquiry report was submitted before the company authority on 10/10/2013. That is, my lord, within less than a year, my lord. Based on the inquiry report dated 10/10/2013, the company authority decided to have a technical verification team. The said verification was constituted to have a spot verification all over the state of Nagaland. Office memorandum dated 9/12/2013 was issued, whereby the technical verification team would be assisted by engineers RMO of their respective areas of inquiry. Consequent upon, by setting up of the technical verification team, an aforesaid office memorandum dated 9/12/2013, the report by the technical verification team have been submitted except by two officers, namely so-and-so, so-and-so, so-and-so. Next para, it is submitted at landed additional advocate in Nagaland that the report of the aforesaid officer is expected within a short period of the completion of the aforesaid report. Of the officers concerned would submit the report to the competent authority in due course of time. He therefore submits that the respondents are sincerely taking up the matter, and therefore the directing the CBI for inquiry in the matter is not called for. On the perusal of the technical verification submitted by the learned additional advocate general and also the inquiry report submitted on 7/7/2013 before this court, this court is satisfied at this stage by the steps taken by the respondents inasmuch as it appears the respondents are acting on the FIR lost. So, my lord, High Court has already, my lord, observed that it is moving in the right direction. However, considering the fact that the two officers, namely so-and-so, so-and-so, so my lord, these are the further direction that they are to complete. My lord, what happened after the order passed by the Honorable High Court of Nagaland, my lord, on 16/6/2014, my lord, the petitioner, what they did, my lord, not satisfied with the outcome of the, my lord, the judgment. And my lord, satisfaction, my lord, it was stated before the SLP was filed before the Apex Court, my lord. So Apex, as Lordship may kindly see the effects, the SLP. Lordship may kindly come to page 106. Whose Lordship got it, my lord? Page 106, my running page.
This is 23/8/2018.
Yes, my lord. In fact, it's from 106 it starts, my lord. It's the first order passed by the Honorable Supreme Court. In fact, my lord, it's against the Kohima High Court judgment. Then what happened, my lord? It was first direction was that SIT constituted way back on 2000. It was order dated 23rd April 2018. And SIT was after 4 years, my lord, and SIT was constituted way back on 29/11/2014 to investigate the complaint made by the petitioner. We are informed that the investigation is almost complete and the report will be handed over to this court. These respondents are directed to complete the investigation and hand over the report to this court within a period of 4 weeks from today. Then Lordship may kindly come page 108. In fact, my lord, this is the order. It is order dated 28/9/2022. But this is important, my lord. From here, my lord, all the case starts, my lord. May I read, my lord? The appellant, who is stated to be a social activist, filed a writ petition in public interest before the Gauhati High Court at Kohima bench, seeking a fair and independent probe into various allegations, including the alleged rampant corruption prevailing in the National Rural Health Mission, for short NRHM, embezzlement, misuse of funds provided in the government of India to the officials in Nagaland state, and for implementation of various programs under NRHM. It appears that after the technical verification and the inquiry report dated at 7 July 2013, a formal FIR number so-and-so, formal FIR number for 2014 dated July 14 on the complaint dated 2nd June 2020 was lost. The High Court, this is very important. The High Court, on perusal of these reports, etc., felt satisfied with the action taken by the respondent authorities towards investigation of the allegations and disposed of the said petition on 16th June 2014. The appellant was dissatisfied with the outcome of her PIL, hence approached this court in the year 2015. So far the satisfaction is concerned, but there is no yardsticks of satisfaction. At what stage one can be satisfied? This is not defined anywhere. But fact remains that that dissatisfied. This is the Honorable Supreme Court also noted. We have heard learned senior counsel on behalf of the appellant and learned Advocate General for the state of Nagaland at a considerable length and perused the records. The allegations of the appellant, among others, is that the engineering division of NRHM made bulk advances in case against various serious works, and kickbacks were allegedly paid to high-ranking NRHM officials instead of extending helping hand to pregnant women or lactating mothers and little children of the public health centers. The funds provided by the government of India were allegedly spent on purchasing high-end luxury vehicles. Learned Advocate General, on the other hand, vehemently denied the appellant's allegations, as according to him, a thorough probe has been conducted and not only a part of allegations were turned down by the Comptroller and Auditor General of India, for short CAG, even rest of the allegations have also been thoroughly probed, and a charge sheet has been filed after completion of the investigation by the Special Investigation Team. Well, after some time, I will come. What is this CAG, Comptroller General? I mean, what the Advocate General had stated before the Apex Court, my lord. In fact, my lord, the Advocate General statement before the court is a statement of the state, my lord. On the other hand, learned senior counsel for the appellant heavily relies upon CAG report, and according to him, most of the allegations were substantiated. Having considered rival submissions, we are of the view that this court is not the correct forum for the investigation or to reach any logical conclusion with respect to the veracity of the allegations leveled by the appellant. Similarly, the impartiality, objectivity, and fairness of the investigation carried out by the SIT will be considered by the court of competent jurisdiction in due course of time. It is inappropriate for this court to make any expression on these issues, as it might unwittingly prejudice any of the parties. The most appropriate recourse, to which there is no serious objection from both the sides, would be to constitute another SIT comprising 3 senior IPS officers of IPS cadre, preferably direct request to further investigate. My lord, Lordship may kindly note the further investigate. My lord, the word further investigation, what is used. So, my lord, come later on, my lord, what further means, my lord. The allegations, and if the substance in such allegations is found, to submit supplementary charge sheet. We direct that the newly constituted SIT shall consist of so and so, so and so, so and so. So, my lord, and then you see Amit Nigam, SP Crime, Nagaland, the SIT so constituted shall look into all the allegations and will further consider. Here again, my lord, the word further consider was used. Consider the CAG report. So, my lord, CAG report remains the basis, my lord, and make an endeavor to conclude the further investigation as early as possible, and preferably within 6 months, and submit his report to the court of competent jurisdiction
Okay,
whereupon.
so
they will-
another SIT was constituted.
Yes, my
by the
lord,
court,
another SIT.
and then they
Ah, my
investigated and charge sheet filed.
Yes, my lord. So, my lord, now the question is that,
Directing the charge sheet.
my lord, Honorable Supreme Court, my lord, so far the first SIT is concerned, neither, my lord, it is set aside, no doubted. Supreme Court, my lord, never doubted the first SIT. But only, my lord, at the prayer of the petitioner, my lord, only observed that, my lord, and as further investigation may be carried out.
Further
Yes, my lord,
investigation,
further. And, my
And
lord,
to
the
file a
SIT
supplementary charge sheet.
exactly, my lord, obliged, my lord. But now, my lord,
So that supplementary charge sheet has been filed.
supplementary charge sheet, my lord, supplementary they have made. And what they did, my lord, supplementary charge sheet they made. Now, my lord, supplementary charge sheet, my lord, come out with, well, my lord, new allegations. And, my lord, they have not, my lord, stated why they differ with the original charge sheet.
That we cannot examine today.
No,
We
no, my
only
lord,
issue
I'm
notice.
coming to that, my lord. So, my lord, as per Supreme Court order, my lord, the CAG report means the basis. My lord, Supreme Court said that you move supplementary charge sheet you filed, and my lord, another SIT was constituted. You further investigation you make, and my lord, considering the CAG report, but if CAG report goes away, suppose there is no CAG report, then my lord, the supplementary, my lord, the investigation also will not continue. Meaning thereby, why will not continue? Because, my lord, they are highly banking upon the CAG report. My lord, CAG report, what happened? CAG report, my lord, CAG report, two types of CAG report. CAG, your lordship is aware. The CAG report is, my lord, is a constitutional functionary under Article 148 to 151 of the Constitution of India. And, my lord, they are the guardian of the state finances. But if there is a, my lord, fund misuse is there, then, my lord, I am coming to that, my lord. I'm
No,
coming.
but on many occasions, we have found that on the basis of CAG report, so motor cases are registered and taken up for investigation.
Yes, my lord.
Many cases
My
are.
lord, CAG, my lord, what CAG function? My lord, here, my lordship, I am obliged, my dear lordship, to point out a very pertinent question, my lord. Here, my case lies, my lord. What happened, my lord? So far as CAG is concerned, CAG, what they do, in every state, my lord, they make an audit of the funds, how these utilized, how they made. What they do, my lord, suppose they find any anomalies, any irregularities, then, my lord, what they do, it is called audit para. Lordship is ever, my lord, audit para. So, my lord, they write to the corresponding department. It's a health department, my lord. So, they write to the health department, these are the anomalies and these are the irregularities. So, look into this.
No, that is a different process. That will government will take up and then it will go to the assembly, some committee of the assembly.
PSC, Public
There's
Health
a
Committee.
PSC and all
my
that.
lord.
There's a long process. But as far as criminal investigation is
My
concerned,
lord.
even basing on the CAG report, so motor criminal investigation can be conducted. That is parallel.
My lord, I am of that. My
Yes.
lordship will kindly see one aspect of it.
There is no wrong in that.
No, my lord,
There's no illegality
why wrong?
there.
Why wrong? I am telling you, why wrong? My lord, when, my lord, the corresponding department is bound to answer to the objection raised, that audit para.
No, they will do that. That will continue.
Ah,
Yeah.
And then, my lord, suppose they are not satisfied, then, my lord, the matter refers to the assembly. I am as obliged to the lordship.
Yes,
So,
yes.
then assembly, what they will do, the Public Accounts Committee will write to the state government to take action accordingly as per the Public Accounts Committee report. That is they will act, the state government will act upon the report given by the PSA, this one, CAG. Now, my lord.
But that doesn't bar the police from also carrying on investigation.
No, my lord, no, my lord. Here, my lord, no, my lord, lordship will kindly see. Lordship will kindly see. Here, another angle is there. My lord, another angle is there. Now, my lord, what happened? Suppose supplementary, my lord, I will come to that.
No, at this stage, we will only issue notice.
No, my lord,
Only issue notice. We'll hear it on
my
another
lord, only,
day
my lord,
after hearing the government and
my
council,
lord, only my lordship will,
after getting their instructions.
my lord, I take your lordship, my lord, intelligence, my lord. Only lordship will give me only 2-3 minutes, my lord. I will just be in brief, I will say where the mistake is, my lord, where the mistake is.
No,
My
we'll
lord,
examine that also. We'll examine
but
that.
then, my lord, state government may file affidavit.
We'll give them time.
And, my lord, they should not proceed because on the first charge sheet, my lord, because nothing was against me. So petition is concerned, there was nothing was there. But second charge sheet, my lord, they find against me, and, my lord, the same sets of, my lord, the materials was available. So when the same sets of materials are available, my lord, they cannot take.
We'll consider the.
They cannot take a different view.
Senior counsel, such and such, assisted by such and such. Please give your names, okay? Such and such. This is an application under section 528 of the BNSS. praying for setting aside and quashing the supplementary charge sheet dated 4/4/2025. Of charge sheet number 2/2019 dated 12/6/2019, filed in GR case number 161/2014, under bracket subsequent to State Crime Police PS FIR number 4/2014 dated 30/7/2014, under sections 406/420/120B of the IPC against the petitioner. So the learned counsel, the senior counsel for the petitioner has challenged the legality of the supplementary charge sheet dated 4/4/2025, dated 12/6/2019, made pursuant to the direction of the Honorable Supreme Court of India, passed by order dated 6/12/2022 in SLP number 31045-31046/2015. So issue notice returnable within 4 weeks. Learned PP S. Mary accepts notice on behalf of
Respondent one to
the
six.
respondent number 1 to 6. Stop. Learned counsel for the petitioners shall take steps for notice upon respondent number 7 and 8 by registered post.
But we have already served notice, my lord.
Already served. Okay. The appearing. Who's appearing?
No one is appearing here, Lordship. They received the notice.
They received notice, my lord.
It is
CJC also, my lord.
about respondent number 7. You say that notice on respondent number 7 has been served on the learned CJC. Stop. Then 8, you have to take steps.
Yes.
8. The petitioner shall take steps for notice on respondent number 8 by registered posts with AD, as well as usual process within 3 working days from today. Stop. The interim prayer shall be considered on the next date. Stop. The learned PP shall file the affidavit in opposition if so advised. If so advised.
My lord,
And produce the scan copies. Scan copies of the case diary. No, it will be trial court report.
It's already charged. It's already.
charge sheet.
Yeah.
So,
The records may be called.
then I'll call for the report.
Mm.
Stop. Call for the records from which court?
This is
Session Judge Kohima, my lord.
Kohima.
From the
Kohima
court of
Session.
the Session Judge Kohima. Scan copies, okay?
My lord, what interim prayer, my lord, my
Yes,
lord.
I've said interim will be considered on the next.
My lord, but till then, my lord, in fact, my lord, so far the petition is concerned, my lord, they will not take effect, my lord, they will others may to be infectious, my lord, case will infectious, my lord. So, my lord, till the next date, my lord, they will not proceed to against the petitioner, but there is nothing against the petitioner, my lord. That is what our prayer. As the lordship will kindly see to page 25 of the petition, my lord. But in the interim, my lord, the operation of the charge sheet dated, my lord, supplementary charge sheet dated has to be stayed so far the petition is concerned, my lord.
Stay will amount to full relief, your lordship.
No,
So
yes.
at least notice has to be completed. Yes.
Kindly appreciate one aspect of matter.
Yeah.
What looks will kindly respect on it. The
No.
whole access will be futile, and my lord, it will be my lord is infectious because what happened, my lord? No, my lord, but till then, but next date, my lord, let them because there nothing is.
Charge sheet is filed now. I'm sure cognizance is also not taken.
My lordship will kindly see, my lord, lordship kindly see. My lord, then, my lord, the issue will be because now, my lord, under this thing, my lord, even the personalized case, your lordship, abuse of the process, my lord, lordship will kindly see, and my lord, if I have the primary facie, I don't have the case, then the matter is different, but we have the primary facie case, my lord. So in such situation, my lord, only, my lord, till the return level date, or till the next date, my lord, let them file affidavit, my lordship will kindly consider. Or till then, my lord,
Okay, till the next returnable date, the proceedings
against the petitioner,
the proceedings against the petitioner shall remain state.
obliged, my lord.
For motion from the supplementary cost list, item number 24.
Please, my lord. Lordship,
IA 96 is for striking off 19 petitioners from the contempt petition. Striking of the names.
Striking off.
What has happened is the state filed SLP before the Honorable Supreme Court in this case, and while the case was pending for at least nearly 3 years, 19 petitioners, some of them, they have resigned and they have joined another new post, as well as 2 has expired. The present from 184 to now, present petitioners are 366 in numbers. Lordship will kindly.
This application has been filed. Praying for striking of the names of the petitioners number
41,
41,
48, 52,
52,
53, 78, 81, 94, 97, 103, 135, 155, 251, 253, 270, 272, 306, 330, 347, 363.
in the from the
COP.
list of petitioners.
Yes.
The list of petitioners in the
COP civil.
COPC number 22/2022.
Yes.
Stop. It is submitted by learned counsel Ms. Z. Zimomi for the petitioners that during the pendency of the contempt petition number 22 of 2022, these 17 petitioners, among these 17 petitioners, some of them has resigned from graduate teachers, from the post of graduate teacher, and 2 have expired. And therefore, the prayer is made to strike out their names from the list of petitioners. So, learned government advocate Mulivika is present and has no objections to the said prayer. So accordingly, the IA is allowed. The names of the petitioners as mentioned above is struck off from the list of petitioners. So the registry shall make the necessary corrections.
Lordship.
Yes.
Lordship,
I will
there
file a
should be an
recast.
amendment.
I will file a recast
Then you file
amendment
recast cost
of the cost title only.
Of the cost. However, your Lordship, again, there is another IA. Here, they're asking for an impleadment in 96. So let the notice go in this case. Only after the impleadment is allowed, only after instruction, then they can go for an.
No,
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 here
because
striking
it-
off is okay. No notice is required.
striking.
No, I'm not talking about this striking
Oh,
off.
the
Your Lordship.
other one.
Other
Acha, wait,
IA.
wait. Anyway, here in this one, the petitioner, instead of registry, now you say that the
Only
petitioner
info
shall
ba?
file
Sabi ba, hindi no?
amended cost title. Okay, then in IA 97.
97.
This is for implement of 2 new incumbent while the case was pending, Lordship, 2 newly incumbent. The other 2 previous one have been transferred out. So now I have filed this implement petition, that is
IA 97. This application has been filed by the petitioner for implement of the new incumbent principal director, Department of School Education as respondent number 4. No, you give the names of the new incumbent Shri Shashank Pratap Singh, the new principal director, Department of School Education as respondent number 4, and Shri L. Jamithung Lotha, Jamithung, Jamithung Lotha, State Mission Director, Samagra Shiksha, Nagaland, as respondent number 5 in the COP number 22 of 2022. So, Learned Counsel for the petitioner submits that during the pendency of this COP 22 of 2022, the officers who are holding the post of principal director and mission director Samagra Shiksha have been since transferred out, and therefore the new incumbents need to be impleted as respondent number 4 and 5. So there is allowed. The petitioner is directed to file an amended.
No, Your Lordship,
the-
notice has to go.
Notice, yes,
Notice
yes,
has to go.
also.
So Lordship, along with the amended
first-
COB as well as with this, if they want this implement also, we can send
First,
together.
we'll say issue notice. Issue notice. The respondents number 4 and
4 and 5.
5, returnable within 4 weeks. The petitioner shall take steps for notice within 3 working days from today. Rest up to 4 weeks.
Obliged, Lordship.
For admission, item number 1.
Petitioner.
No.
None appears for the petitioner when the matter is called. So Learned PP, which Mommy is present. So please the matter after the summer vacations.
Obliged.
Item number 2.
My lord, here I'm for respondent number 2 and 3, Lordship. My lord, the matter has been forwarded to the finance department for necessary steps, Lordship. So if Lordship may please release the matter after the vacation, Lordship.
Pending bills.
This is, yes, Lordship. This is with regard to the pending. bills,
Additional amount, some additional.
Lordship, 97 lakhs. That matter has been before the finance department, Lordship. So
None appears for the petitioner when the.
Your
matter-
Lordship, I'm appearing on behalf of the petitioner.
and for the through VC.
But sometime they need some, they're saying it's with the finance department now.
Yes, Your Lordship.
How
Your
much
Lordship,
it take?
3 weeks time,
3
Lordship.
weeks.
Lordship,
You're
after
sure?
vacation, Lordship. Lordship, I will take a necessary instruction, Lordship, from the finance department as to whether.
Yes, yes. What did you say?
Your Lordship, on the last occasion also the respondent, they have taken time stating that only one approval is needed. Your Lordship, that has become a routine for them. Every now and then they keep taking time. In fact, the proposal for additionality was sent in last year only, in 2024.
Yes, last time also you said it's with the finance.
Lordship. So, Lordship, I may allow to take a necessary instruction, Lordship, since the matter is lying there, Lordship.
You personally take steps.
Your Lordship, my humble prayer is that give strict directions to the respondent because it's become very routine for them to keep taking time.
This was filed when? 24.
This was
Yes,
filed
Your Lordship.
24, Lordship.
Heard Miss Farhana Ahmed, Learned Counsel, appearing for the petitioner. So also heard Mr. V. Jimomi, Learned Counsel, appearing for respondent number
2 and 3.
2 and 3.
Lordship.
It is stated by Mr. V. Jimomi that the approval of the finance department is still awaited,
Lordship.
and for the release of the additional amount of rupees 97.54 lakhs. Although the proposal for the pending bills were placed before the government on 8/10/2024. So he has prayed that he may be given another 3 weeks time within which the pending bills will be paid. Stop. Prayer is allowed. This is the matter after 3 weeks. Stop. In the event that the pending bills are not paid.
Lordship, since it's a financial, there is a huge financial implication, Lordship. So if Lordship,
97.54 lakhs, actually, that's not too much for the government.
Lordship, I'm allowed to take an instruction, Lordship, since.
Okay, we'll say as a last chance.
No.
As a last chance. 3 weeks after.
Obliged, Your Lordship.
Item number 3.
Your Ladyship, in this matter, I've been informed that the matter has been charge sheeted. So
Then we'll have
if the
to
scan
call-
copy, yes.
None appears for the petitioner when the matter is called. Stop. Learned public prosecutor Mrs. Mary submits that the matter has now been charge sheeted and therefore the records may be called for. Stop. Accordingly, call for the scanned copy of the trial court records from the court of
Dimapur CGM.
the court of learned CGM Dimapur. Court of learned CGM Dimapur. List after
vacation.
After vacation.
Obliged.
Item number 8.
May I please, Your Lordship? Your Lordship, here we have filed our affidavit in opposition this morning, Your Lordship.
Petitioner is not there. None appears for the petitioner in the matter is called. Learned counsel. You are?
I'm Solo, Your Lordship, for the respondent.
No, your name.
I'm Solo, Your
Such
Lordship.
and such, appearing for respondent, which respondents, all
Sole respondent, Your Lordship.
for the sole respondent submits that they have filed their affidavit in opposition this morning.
Your Lordship.
Therefore, leave the matter after the summer vacation for this is for orders. For orders.
For admission, Your Lordship.
Not admission, huh? For orders, for admission.
Lordship.
For admission. Are you appearing for the petitioner?
No, Your Lordship.
I'm appearing for the respondent along with M. Solo. 8 and 11 are connected. Plus.
Lordship, if that we fixed. Your Lordship. 21st, Your Lordship.
21st.
Lordship.
21st July.
Much obliged.
For admission from the supplementary cost list, item number 25 and 26.
May I please, Ladyship?
Please, my Lordship.
Yes. Please.
Lordship, by the order dated 6/02 of 2025, passed by this honorable court, Lordship. The court has agreed upon the suggested arbitrator, so both the arbitration petition and the civil revision may be closed.
Am I audible, my lady?
Yes, yes.
Lordship, here I am appearing for respondent in item number 25, Your Lordship. The learned arbitrator entered reference, Your Lordship. The first sitting was on 29th of March, Your Lordship. So item 25 may be closed, Your Lordship, but 26, I have a different submission to make.
You are not audible.
Oh.
Item, wait.
Item 25 and 26.
Am I audible, Your Lordship, now?
Yes, yes.
Lordship, here on
Item 25 should be closed actually, isn't it?
Yes, Your Lordship.
Yes, because arbitrator has already been appointed.
Yes, Your Lordship. And he has entered reference also, and pleadings are almost completed, Your Lordship.
Okay, and then civil revision can continue.
Yes, Your Lordship. Civil revision can be closed, Your Lordship, because the order of the trial court was, we challenged the order of the trial court, and while order dated, this honorable court was pleased to stay the order of the trial court on 2nd September 2024. So this CRP can be closed by setting aside the order of the learned trial court, Your Lordship.
First, we come to this arbitration.
Yes, Your Lordship.
Learned counsel for the petitioner, you are Miss P. Chetri.
Yes, Your Lordship.
Chetri. And also the learned counsel for the respondent.
Your Lordship, here I am the respondent.
Lordship on the
Oh,
petitioner.
Okay. Petitioner and then respondent P. Chetri. By order dated 6/2/2025, this court has already appointed Honorable Mr. Justice C.R. Sharma, retired, as the arbitrator in the case. So accordingly, the arbitration petition 3/2024 is disposed of. Okay. Then come to Civil Revision 17. In Civil Revision 17, what were you saying?
Lordship, here in civil revision, the learned
You are
trial.
the petitioner.
Yes, Your Lordship. Here I am the petitioner, Your Lordship. The learned trial court granted ex parte interim stay, Your Lordship, wherein he did not have the jurisdiction to pass such an order, Lordship. The order, you'll find it at page 12, Annexure 1. This is the order dated 5/4/2024. Leadership can come to page 15, Your Lordship. Para number 6, if I may read. Having referred the matter to arbitration, the ad interim injunction order dated 14/9/2023, passed in IA Civil 69 of 2023, will remain in force till the arbitration process is completed. It may be noted that by order dated 14/9/23, the applicants/defendants were restrained not to give effect to the letter date number so-and-so, dated 11/9/2023, issued by the signature of AP Airport Director so-and-so, debarring the respondent/plaintiff for 3 years from participating in the tender process of AI. Further injunction was passed against the applicant defendants from publishing the letter dated 11/9/2023 in their website. Lordship, here, as per the agreement, there was arbitration clause. The plaintiff did not file any application appointing arbitrator, directly file a civil suit before learned session judge in Dimapur. Thereafter, this order was passed, Your Lordship, wherein the respondents was debarred from publishing the name of the plaintiff. Your Lordship, this order was challenged by us in this before this honorable court, and which was stayed. Thereafter, now the matter has been referred to arbitration, Your Lordship. Hence, my prayer would be to set aside this portion of the order, Your Lordship.
Yes.
No, Your Lordship. I was in the other court, so I'm not fully.
No, as far as arbitration is the arbitration petition is concerned, we have disposed it of, because once arbitrator is appointed, it cannot be kept pending.
Yes, Your Lordship.
Yes. So we
Now,
have disposed it.
what I
Now
wanted
this civil-
to impress upon Your Lordship before this honorable court is, whatever contentious issues are there, it will be decided by the arbitrator now. So, Your Lordship, the earlier order passed by the learned court below, that is no more in existence. Everything goes with the appointment of the arbitrator. All contentious issues will be tried by the arbitrator. So now, to express any opinion on the proceeding which is about to take place. Yes, Your Lordship.
Because now that the arbitrator is appointed, now all the issues will be decided by the arbitrator.
Lordship.
So this civil revision also, we have to dispose it of, because now
Yes, Your
it is
Lordship.
no more.
In fact, everything goes.
Your Lordship, if I may.
Yes.
Your Lordship, if the CRP is disposed of with a simple direction that it is disposed of, the interim gets vacated.
Interim goes.
Interim goes, my interim goes.
Interim will go, the district judge order also will go.
Yes.
It will be in operation, Your Lordship, because the very fact, if this order of this honorable goes, then the order of the learned trial court might revive, your lordship. That's why I'm asking, seeking a direction in
Your
this.
Lordship, the doctrine of merger with the final order, everything goes, doctrine of merger. I hope my learned friend will surely be aware of doctrine of merger. Everything goes with the final order.
When this
No
petition
interim
is
survives.
closed, then only the arbitration remains.
Yes, Your Lordship.
The impugn order also goes.
My Lord,
Yes,
everything goes.
everything goes.
Your lordship, the impugn order may not go, your lordship. Because
How will it survive?
Your lordship, because the order was passed on the application filed by me under Section 8 of the Arbitration Act. We apprise the learned trial court that there is an arbitration clause, hence that petition may not be entertained, and to refer the matter for arbitration. The learned trial court on my application, lordship, passed such an order, your lordship. That's why, your lordship, the
My Lord,
order.
if my learned friend is feeling insecure, then my Lord can add a sentence saying that everything goes.
Your lordship, it's not about the insecurity feeling, your lordship.
Because the law is settled, doctrine of
Your
merger.
lordship, a small direction. I'm seeking a small direction, your lordship.
I will cover that also. Don't worry.
Lordship.
It will be in the interest of my client, your lordship.
Yes, civil revision, something. In view of the appointment of the arbitrator in that arbitration petition number 3 of 2024, all the issues raised in the present civil revision petition will be decided by the during the arbitration. So accordingly, civil revision 17 of 2024 is closed. Stop. Is disposed of. In view of the appointment of the arbitrator. It is made clear that all proceedings arising out of the present dispute and consequential orders what do I do? Consequential orders will not be operative. Will not be operative
My
in
Lord.
view of the arbitration proceedings.
Your Lordship.
Petition stands disposed of. That will cover you.
Oblige, Your Lordship.
Oblige, your lordship.
For orders, item number 9.
Members, my lord. On the last occasion, counsel for the respondent number 9 and 10 were directed to obtain instruction.
Instructions.
Yes.
Anyone for respondent 9 and 10? Mr. Ip
Sure.
Kim Song was appearing, I think.
Yes, he was available as of now, but then I think
He must be in the
it's
other.
before court one, yes. But then I was informed that he got some instruction from the finance department.
He has some instruction.
Yes, 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 but then yet to file affidavit.
Yes.
He's engaged in court number 1.
Okay. So should we wait or we'll list it
Let it
another
be
day
missed after vacation.
after vacation?
After vacation.
On the pair of the parties, list the matter after the summer vacation. On the next returnable date, the respondent, the counsel for the respondent number 9 and 10 shall apprise this court about the instructions received in the matter.
Oblige.
Much obliged.
Item 11.
Yes, your lordship. Your lordship, I've received affidavit. Just their affidavit just today, so kindly grant us some time to go through.
Learned counsel for the petitioner, MS such and such submits that the affidavit in opposition of the CBI.
The respondent.
Respondent,
So respond, Your Lordship.
also respondent has been received by her only this morning and accordingly praised for some time to go through the same and file reply if so advised. So please the matter after summer vacation.
Your Lordship, Your Lordship, if the matter can be listed with item number 8, Your Lordship, criminal
Revision 2 of 2025, your lordship.
When did we fix that one?
21st, your lordship.
On 21st July. It's the matter on 21st July, along with,
Yes. Criminal revision
with the
2 of
number.
2025.
Is it connected?
Yes, your lordship, connected, your lordship. Ashok lordship.
Item number 13.
May I please, Lordship? Lordship, service report is returned. And
Return,
but
notice upon respondent
but jurisdiction,
has been returned back
yes,
to the registry.
but the police officer in charge of Diffuper PS stated that jurisdiction doesn't fall under them. So it falls under the suburban police station.
Jurisdiction of suburban police station. Address to the officer in charge, suburban police station. Action. Then you take first steps.
Yes, on 25 also we
be-
took steps, Lordship. Lordship, I'm paying for interim relief. Mainly, we'll take fresh step obviously, but I'm paying for interim relief. The matter is of civil dispute. Lordship. The dispute is of civil nature. The respondent number 2 filed a FIR against the accused for non-delivery of machineries for manufacturing of raw agarbatti plant in Dimapur. He was supposed to deliver the machine within 16 days, 60 days, sorry. Rupees 25 lakhs 19,000 was paid to the informant by the SBI. After that, the respondent number 2 requested the accused to give rupees 5 lakhs 95,000. On good faith, he gave rupees 5 lakhs 95,000 to him. And respondent number 2 never returned the sum. So he could not deliver the machinery on time. And right now, they have filed a money suit also. Yeah, I have annexed it. Page number 29 for recovery of money. So I'm suffering from double jeopardy losses. So I'm praying that the matter is
On the same issue,
yes, on same issue. So I'm
recovery of 33 lakhs 2092.
and it is pending before the civil judge senior division Dimapur, Lordship. So matter will be state. Service is not complete yet.
Lordship, let the service be complete.
Lordship.
Complete. Because the complainant is the main party.
Yes.
Yes.
The state is just for forma.
Yes,
Yes.
but Lordship, for the 4th time we are here for this case.
No, but,
And we took twice, 2 times we took
But you must
steps.
have taken in the wrong police station, na?
Yes, yes, yes.
That is the problem.
For the next, for till next date, interim may be allowed, Lordship, at least. Dispute is of civil nature, and they have also filed a money suit. It is also pending.
No, your lordship, allegation has already been materialized into charge sheet. And there is prima facie case, your lordship.
No, Lordship.
Yes,
Yes,
it's
already-
charge sheeted, and on the last occasion, LCR has been called.
Yes, LCR.
Yes.
And now fixed for CC. That's why I'm praying for interim.
At least let the notice be complete and then the matter may be heard.
Now matter is fixed for CC,
But
Lordship.
again, if CC is done, again, it will create
Yes, yes.
implication.
That's why. Lordship.
I don't know, I thought it was still investigation stage. Learned counsel for the petitioner, she is certain that she is present. Office note indicates that the notice on the complainant respondent number 2
Yes.
is yet to return. So, a letter has been received from the officer in charge, Tipupar Police Station, stating that the concerned police station should be suburban police station, Dimapur. The petitioner is directed to take steps, fresh steps for notice
Yes.
on the respondent number 2 through the OC of the suburban police station, Dimapur. Stop. The LCR, the DCR has been, scanned copies of the DCR has been received. Which order? You do know which date? When the CC has been fixed?
CC, Your Lordship. Hold on, if I order the date. We have annexed the, yes. Page, annexer 424, page number
No,
24.
order dated
Order dated 6/2/2025. Page number 28 in the operative portion is at page number 28.
no 18/3. It was fixed on 18/3.
Yes, we took adjournment on that day,
And next date is when?
on 29 July, Lordship.
29 July.
Yes, Lordship.
A perusal of the trial court record shows that on 6/2/2025, the learned trial court has fixed the case for consideration of charge on 18/3/2025. Stop. On 18/3/2025, the petitioner / accused prayed for some time, and the matter was refixed for consideration of charge on. No, it says 2/6. So maybe on 2/6 again, and again you sought adjournment.
No.
Next date is given for 2/6/2025 for CC.
18/3, it page number 28, 18/3, Lordship.
On 18/3, I'm looking at the trial court records.
Okay.
Yes.
Okay.
On 18/3, it says learned counsels are just present for accused and prays for some time. Prayer allowed, fixing 2/6/25
Yes.
for CC.
Yes.
Then what happened on 2/6?
On that day, we have informed the court below that we have filed this criminal petition. Yes, and
We fix on 2/6/2025. Stop. Learned counsel submits that on 2/6/2025, another prayer was made for adjournment, and the learned trial court was pleased to allow the prayer for adjournment and refix the matter for CC on
29 July.
29 July
Yes.
2025. Stop. Accordingly, till the next returnable date, the proceedings in GR 384/2022 shall remain state.
Obliged, deeply obliged. A date may be fixed, Lordship, if possible.
Fixing,
In the month of August last part.
no, not last part. You take fresh steps and then it may take a month. So just say 30th of July, 30.
30.
Yes.
Okay. Obliged, Lordship.
For hearing, item number 19.
Actually, I think there's a part-heard matter.
Your Lordship, we praying for another some time to file our additional affidavit.
Additional affidavit.
Yes, we're for the petitioner.
Petitioner.
Yes.
Learned counsel, MS and such, appearing for the petitioner, has prayed for some time to file an additional affidavit.
Yes.
Stop. Praise allowed. How much time?
3 weeks.
Least after 3 weeks. In the meantime, the petitioner shall file the affidavit, additional affidavit.
Obliged.
So, but, with the first, what about the others? Here also there's more. You point this first one.
For hearing from the supplementary cost list, item number 28.
Joshua and Mr. Imti Imson. Is appearing in item 20. Hearing item 20, you're appearing. Yes. You're ready. Yes.
He's in call number 1, madam.
He's on legs.
Yes, he's coming, he's coming.
Oh.
My lord, when we are waiting for them, why don't we take up item number 22? It is a short matter, my lord. Basing on the affidavit filed by the state, the matter can be closed, my lord.
Item 20.
Yes, my lord, hearing. It is a short matter, my lord.
Okay, what is it about?
Yes,
My
my
lord,
lord.
here, out of 30 petitioner, item number, petition number 30 case has been considered. Now 29 is remaining, and it is under consideration. It is before the BNR.
Lordship, here the facts of the case is that the petitioner is being covered by OM 17/3/2015, where the OM states that if a work charge employee in scale, if he completed 30 years or more, then this shall be.
That one.
Yes.
Just on that ground, I filed this application, and then as stated by the council, they've filed an affidavit. Where it paragraph
Para 3.
they've clearly stated that affidavit of respondent number 1 to 5. Mary, your lordship. Since they are stating that petitioners 1 to 9 names have been forwarded to government for approval as per the.
1 to 29.
Yes, 30 has been regularized.
30 already regularized.
Yes, regulation order has been enclosed at page 10.
Okay, we can
Yes.
dispose with a certain time frame.
Yes,
Yes,
my lord.
lordship.
How much time?
At least 4 months, my lord.
4 months.
Yes.
Item 20. Okay. This application has been filed by the petitioners 1 to 3, who are all work charge employees serving under the Department of Public Health Engineering, Nagaland, Kohima, and had retired from service from the year 2020 to 2024. So the instant writ petition is has been filed, praying for a direction to regularize the services of the petitioners as per the provisions of the Office Memorandum Number capital AR-GEN-201/2009 dated 17/3/2015, issued by the Government of Nagaland. Stop. I've heard learned counsel for the petitioner, Mr. S. Walling, and Mr. Tibapong for the state respondents. Stop. The state respondents have filed an affidavit in opposition by which it has been contended that during the pendency of the writ petition, the service of petition number 30 has already been regularized by office order dated 13/9/2024. Stop. This is not disputed by the learned counsel for the petitioner. Stop. It is also stated in paragraph 3 of the affidavit in opposition of the state respondents that by a letter dated 19/4/2021, a proposal for regularization and absorption of work charge employees has been forwarded to the government, wherein the names of the petitioner number 1 to 29 are also reflected under Kiferi division. And the matter is now pending before the government for approval. So. Next, in view of the above facts and circumstances, the writ petition is disposed of at this stage with the direction to the state respondents to complete the regularization process of the services of petitioner number 1 to 29 within a period of 4 months from today. In pursuance of the Office Memorandum dated 17/3/2015. The writ petition stands dismissed.
Much obliged.
My pleasure.
For hearing, item number 28.
Please, your worship.
One minute, okay. There are so many affidavits, so I have to
Yes.
sort them out. Government has filed one affidavit and then another additional.
Yeah, additional affidavit incorporating that pay anomaly report.
Yes.
Worship here, as per the direction of the Honorable Court, the state respondent has filed a report of the committee, pay anomaly committee on 3rd September 2024. So in that report also, it is clearly mentioned that the representation, the prayer of the those petitioners were rejected.
But why the ROP says corresponding ranks in the police department?
Yes,
So according to you, see at the rank of assistant commandant, DOSP,
yes,
they are same, isn't
yes,
it? Even
yes.
the VGs as well as the Nagaland police, they're getting the same pay scale
Yes,
and everything, but
below.
suddenly come down to Subedar, Major and Jamidar, then Jamidar is getting constable
Yes,
scale. So how that hierarchy is maintained?
yeah, Lordship, I'll explain. See, why? The reason is why, and even the court wants to know as to
Yes.
why. Lordship here, in order to understand this and in order to come to the conclusion and to agree with the decision of the government is that those police force, regular police force, they have their own role and they
Yes,
have their own service role and duties and functions are quite different. And those petitioners, they are village card only. And most of them, they are selected by the village council and again by the deputy commissioner, deputy commandant. So the footing is quite different. So the government has taken a policy that to a certain category of officers, we have considered and below that it is not. Why? Because we have to base on the footing, how they have appointed, how they have recruited, the mode of recruitment. So that is a reason behind.
they are appointed by whom?
Those village card, they were appointed, those lower bank, they were appointed by the villagers, village council. And deputy
No,
committee.
in the orders, it appears they are appointed by the Commissioner Nagaland.
No, higher rank.
Commissioner Nagaland.
Yes, but in the lower rank,
So that is
supply.
different.
Yes,
Because here they are not, the lower ranks are not here.
yes,
The persons before this court are Jamidar and Subedar majors.
yes.
Mm.
So whether they are appointed by the commissioner or deputy commissioner, but the works and nature responsibility, those are quite different. And now the petitioner wants to, they are claiming that at par with the regular police, they want to enjoy the facilities. So to a certain extent, government has accommodated. But the thing is, as I repeated, mode of recruitment is quite different. And duty and responsibilities are quite different. So the government has come extended to only a certain portion. So that is a reason behind. Yes.
Different, and then. What about qualification? What is the qualification required for Jamidar?
Jamata is matriculate for 30 requirement and again under promotion, seniority basis. Your Lordship,
Jamadar is matriculate.
yes, Your Lordship, it is clearly mentioned in my affidavit, page number 3. Affidavit, page number 3, paragraph 4. Village card,
Yes.
assistant commandant promotion. Second is superior major promotion, superior promotion, Jamadar promotion or direct recruitment. Qualification and matriculate for direct recruitment, promotion on the basis of his seniority from HM. Havildar major NRHM, voluntary no educational qualification required. And below down there is no qualification at all. So even the Jamadar, even though they were not appointed by the government, but they are promoted to, they have a scope to reach the Jamadar and above also. So their recruitment, their footing doesn't make difference. And again, below there, Havildar, Naik, Lasnak, and Sobe, they're all voluntary, no education, academic qualification is required. Whereas in the next paragraph, Deputy Commissioner, promotion, Armed Branch Inspector API, promotion, and Armed Branch Sub Inspector ABSI, promotion and direct requirement. Their backward tribe is class 12 general graduate. And below there, Havildi, all promotion. And you see the starting. Here, Your Lordship, the distance is police constable, no, serial number 7, direct recruitment. So there is a distinction is given. Backward tribe is class 8, general class 7. Whereas in the police card, that is serial number 9, Subai, is all voluntary, no educational qualification requires. So in do a certain action, it covers a lot. So it makes a difference. And regarding the how the pay and scale of pay were considered, it was clearly mentioned in my affidavit para number 9 and 10.
You don't have service rules, no?
No service role yet.
For them, Jamadar is the entry level
Yes.
and police, it is constable. So below Jamadar, these are not government employees. Below Jamadar,
No, actually,
they are not government employees. These
no, as per the scale of pay, it is, but they are appointed. And actually, their salaries are borne by the Home Ministry from security expenditure side. So we cannot say that they are not government servant, but the way they render their service and the purpose of the government to requisition their service is such, but they are not covered by that
because
facilities.
here in your chart, it says honorarium.
Honorarium.
Honorarium. So that means Havildar major and below, they are not paid this pay scale. They are not given
No,
a scale pay.
it is not. Well, it's starting from Jamadar only.
So from Jamadar
So,
only,
Your Lordship, there's a difference here. Even though Havildar major is not, but there is a scope to promote to the higher job. So that time he will enjoy the skill.
okay, so from Havildar major, if he is promoted to Jamadar, then he will get the pay scale.
Yes. So the Jamadar, he may be appointed directly recruited or by promotion. So the starting point, the starting is the started from this Subai. where no qualification is required at all. So that makes a difference. So regarding the pay scale, to a certain extent, I have stated it is covered, but Your Lordship here, I want to highlight to the point that as to why the state has opted only to cover only the certain category of officers. So I just want to highlight the Honorable Court by relying on the some ruling of the apex, Honorable Supreme Court. Your Lordship here, I need to confirm one. Whether light blue is light blue, it cannot be relied, no? Okay, let it drop it. Your Lordship here, in order to accommodate those certain conditions, certain prerequisite condition is required. So in order to qualify the prayer of the petitioner, we have to see the nature of the work.
What's this? Government of Nagaland Village Guards Service Rules?
No, it is not that notified. It is under process only. So we have to see that whether they are entitled to enjoy the facilities about the regular police. So we have to see the nature of the work. You see, Nagaland police or whoever the regular police, they have guided by the law, and their duty and function and responsibilities. It is for entire state, and they are accountable to the law. Whereas it is very clear that Your Lordship here, the village guard, their duty is required only as some pocket of the state only, and few districts. And even if there may be some other emergency work, it is confined only to a particular area. Whereas the police, they can go outside the state also as when it is required by the central government. So we have to see that also. And again, qualification. See, as I have stated, a starting point is no qualification. Above also, it is recommended and selected by the village council, and those who entered in the early age.
Just come back.
Okay. Before last, look at the water.
Yes.
Lordship here, just to save time also, I just want to, without highlighting the entire fact of the case, I just want to allow me to highlight only the principal law in which para it was highlighted. So, Lordship here in the Honorable Gauhati High Court, in one case which was reported in 2023, 2 GLD, page 919. Nirav Chandra Adhikari versus Union of India and others. Paragraph 14, 15, and 16.
Paragraph 14.
15 and 16. This is regarding the appointment of the senior research assistant under the Institute of Advanced Study in Science and Technology, IASST. So here, Lordship here, the Honorable Court has clearly held that in order to claim the parity, mode of requirement is a relevant factor.
Paragraph 14.
Paragraph 14.
Yes,
Lordship?
yes.
Paragraph 14. The answer to the said contention can be found from the judgment of the Supreme Court in the case of State of Bihar and others versus Bihar Secondary Teachers Struggle Committee, Moker, and others, reported in 2019, 18 SSC 301, wherein the Supreme Court was dealing with the nature and duties performed by the neoget teachers with the government teachers. In paragraph number 87 of the said judgment, the Supreme Court had categorically observed that the neoget teachers as well as government teachers performed the same nature of duties, and both the set of teachers taught in the same school as well as the same syllabus. The Supreme Court in the said judgment referred to the earlier case laws in copious detail. In doing so, in paragraph 96.9, the Supreme Court observed that before entertaining accepting the claim based on the principle of equal pay for equal work, the court must consider the factors like source and mode of recruitment, appointment. This court find is relevant in this stage to refer to paragraph number 100, 101, 102 of the said judgment, which are reproduced here and below. Paragraph 100 is, we may at this stage deal with the submission advanced on behalf of the state that the decision in Justice Singh did not take into account the earlier decision rendered by this court in State of Punjab versus Joginder Singh and Zapar Singh versus State of Haryana. In the first case, respondent Joginder Singh was working as a teacher in District Port High School in Hoshiarpur before 1st October 1957. By reason of government decision taken in September 1957, which came into effect on 11 October 1957, all teachers like respondent Joginder Singh employed in the port and municipal port school became state employee. Before such decision was taken, the state had decided to have two categories of teachers working in the state service. 15% of the total strength of teachers were put in middle scale of salary scale, while the rest, 85% were put in the lower scale. The former thus had better chance of promotion to further level after taking over the school run by the district port and municipal port, which was called provincialization. Can I pronounce it? Yes.
Provincialization.
The teachers like respondent Joginder Singh, though became state employees, were part of the cadre of provincialist teachers, which was distinct from the cadre of state teachers. A decision was also taken not to make further appointment in the provincialist cadre, and thus the said cadre was to be tying or Venetian cadre. It was also decided that the provincialized cadre would stand bifurcated on the same pattern of 15 into 85 was done in state cadre, but any requirement in the provincialist cadre would not result in fresh appointment in that cadre, but the appropriate number would get added to the state cadre and fresh appointment would be made only in the state cadre. It must be noted that the employees in both cadres were given the same pay scale, but their chances of promotion were completely different. The submission that with the passage of time, the strength of provincialized cadre would keep reducing, and as such, the chances of promotion and being part of 15% group would keep diminishing, and as such, the employees in the provincialized cadre would be put to prejudice was accepted by the High Court. It was observed by this court in state of Punjab versus Joginder Singh as on the ARP page number 921 to 22. No remain, continuation, it no remains to consider point which was raised that the state cannot constitute two services consisting of employees doing the same work, but with a different scale of pay or subject to different condition of service, and that the constitution of such services would be violative of Article 14. Underlying this submission are two postulates. Equal work must receive equal pay, and if there be equality in pay and work, there have to be equal condition of service. So far as the first proposition is concerned, it has been definitely ruled out by this court in Kishore Mohanlal Bakshi versus Union of India, Das Kapta J. Speaking for the court said, the only other condition raised is that there is discrimination between the class 1 and class 2 officers in as much as though they do the same kind of work and the pay scale are different. Thus, in this, it is said, violate Article 14 of the Constitution. If this condition had any validity, there could be no incremental scales of pay fixed dependent on the duration of an officer's service. The abstract doctrine of equal pay for equal work has nothing to do with Article 14. The condition that the Article 14 of the Constitution has been violated, therefore, also fails. The second also is, in our opinion, unsound. If, for instance, an existing service is recruited on the basis of a certain qualification, the creation of another service for doing the same work, it might be in the same way, but with better prospect of promotion, cannot be said to be unconstitutional. And the fact that the rules frame permit free transfer of personnel of the two groups to place held by the other would not make any difference. We are not basing this answer on any theory that if a government servant enters into any contract regulating the condition of his services, he cannot call in aid of the constitutional grantee because he is bound by his contract. By this conclusion, raised on the different and wider public grounds with that the government which is carrying on the administration has necessarily to have a choice in the constitution of the services to man the administration, and that the limitation imposed by the constitution are not such as to preclude the creation of such services. Besides, there might, for instance, be a temporary requirement to meet an exigency or an emergency which is not expected to last for any appreciable period of time. To deny the government the power to recruit temporary staff trying the same pay and doing the same work as other permanent incumbent within the cadre restrained by the government by different rules and conditions of service. It might be, including promotion, would be to impose restraining on the manner of administration, which we believe was not intended by the Constitution. For the purpose of the decision of this bill, the question here discussed is rather academic, but we are expressing ourselves on it in view of the argument addressed to us.
I think you should come to para 14, the last part, just above para 15. Ordinarily, a pay structure is evolved keeping in mind several factors.
Paragraph 15.
The paragraph just above paragraph 15.
Paragraph 14 that small serial number
Small
job.
12, yes.
In ordinarily, a BI structure is evolved keeping in mind several factors. For example, method of requirement, level at which requirement is met, the hierarchy of service in a given cadre, minimum educational public technical qualification required, avenue of promotion, nature of duties and responsibilities, the horizontal and the vertical relativities with similar jobs, public dealing, satisfaction level, employers' capacity to pay, etc. We have referred to these matters in some detail only to emphasize the several factors to be kept in view while evolving a pay structure and the horizontal and the vertical relativities, that's also difficult for me to have to be carefully balanced, keeping in mind the hierarchical arrangement, avenue for promotion, etc. Such a careful evolved pay structure ought not to be ordinarily disturbed, as it may upset the balance and cause avoidable rebels in other cadre as well. So para 15, from the above quoted paragraphs, the said judgment, it would transpire that the mode of requirement can be taken as a factor for the purpose of accepting or rejecting claim based on the principle of equal pay for equal work. It also will be relevant herein to take note of that petitioner service is not transferable, whereas their services of technical officers grade 2 are transferable, and as such, they fall in a different class from that of the petitioner.
Okay, okay.
So,
So that you want to say that the mode of recruitment
yes,
is important.
it is very relevant here. Even the transfer of bullies and the home card, Woolish card. Your Lordship, again, I will be allowed to refer to another GLD, 2022, volume 6, GLD, page 486, Chitendra Komartas and others versus Eastern Assam. Here, Your Lordship, in this case, the Honorable Court, our Principal Court has clearly held that the issue on pay, fixation, and revision firmly dominate executive. So here, I would like to refer the limited paragraph, para 9, 11, and 15. Para 9, 11, and 15.
Just later, no, will give me photocopies of these pages only. I don't know what just the relevant pages you photocopy. Yes.
May I read the para 9?
It's okay.
Para 9,
9,
11,
and
15.
So the proposition here is that the matter of pay fixation and parity should be left to the
Executive.
executive.
That the principal held that it is and next is again, I mean, we're allowed to come to the again GLD 2022 6 GLD 847. This is regarding the fireman Tomo Nombok and other versus set up Arunachal Pradesh.
Same volume.
Page 847.
Fireman, Tanagar bench.
Tomo Nombok. Paragraph 16, 18, and 19. Here also same thing as claimed by the petitioner. Those fire services of Arunachal Pradesh, at part they want to claim that general police, whereas the honorable court has rejected their claim. So my reliance is para number 16, 18, and 19. Here the para 6, 16.
16, 18, 19. Okay.
To bring home the contention regarding differential treatment, the initial burden which is required to be discharged by an incumbent is that there is one homogeneous class in which a differential treatment is sought to be given. The onus would then shift on the other side to establish that the said classification is a reasonable one, as there is an intelligible differential and that the same has been done in presence of an object to be achieved. Para 18, the case of the petitioners who are firemen is that they are at bar with the post of constable in the other three segments of the Arunachal Pradesh Police, and to substantiate the said point, the parity in the scale of pay has been highlighted. However, what is required to be seen is as to whether only parity in the scale would make the services equivalent at bar. The condition of the state will be referred to answer this query. The state has contended that the function and duties of firemen is only related to firefighting and are wholly different from that of constable in the other three segments of the Arunachal Pradesh Police. It also transpired that while there is one requirement rule for the fire services, there are another requirement rules for the rest of the three segments. This court also find force in the requirement of the state that similarly based scale are also given to certain ministerial posts like LDC, UTC, which will not mean that the services are similar. There is no manner of doubt that while a constable is required to discharge of his duties on a day-to-day basis, just the position, the duties of the firemen are to be performed only in emergency. Of course, the firemen are required to stay alert at other point of time also, but the same is definitely a case which is different from discharge of actual duties. Para 19. Though in view of the above discussion, wherein this court has arrived at the finding that there is no classification as such in a homogeneous group, and therefore the challenge is a misconceived one. This court has noticed that even on factual office, the challenge has been inherently structured. So that is a decision of the Honorable Court. The firemen services and the regular police are quite different. Now I would like to shift to the ACC, the decision of the IPS Court. I would like to rely on a case where reported in 2004, Volume 1, ACC 347. Government of West Bengal versus Darun Kumar Roy and others. Para number 14 and 20. Here, the principle held by the Honorable Court was that the source and applicability of doctrine held its emphasis in Article 14, read with Article 39D of the Constitution, is not automatically applicable merely on basis of identicalness of work, irrespective of educational qualification, source of recruitment, or other relevant consideration. So I may be allowed to read the paragraph 14.
Equal pay for equal work.
Equal pay for equal work. Paragraph 14. Article 14 with the Article 39D of the Constitution of India emphasizes the doctrine of equal pay for equal work. The said doctrine, however, does not contemplate not only because the nature of the work is same, irrespective of educational qualification or irrespective of the source of recruitment, or other relevant considerations, the said doctrine would automatically applied. The holders of a higher educational qualification can be treated as a separate class. Such classification, it is the right, is reasonable. The employee performing the similar job but having different educational qualification can thus be treated differently. Para 20. The question of violation of Article 14 of the Constitution of India on the part of the state would arise only if the persons are similarly placed. Equality clause contained in Article 14, in other words, will have no obligation where the persons are not similarly situated or when there is a valid classification based on a reasonable differential. The doctrine of equal pay for equal work, therefore, is not asserted in the instant case. So Willis card is, they are not in the same establishment with the general police. So that is the authority of the Honorable Apex Court. Lordship, again, I would like to refer to SSC 2012, volume 12, page 666. Hokum Chan Gupta versus Director General in Indian Council of Agricultural Research and others, para 20 and 21. Here it is held that neither Central Administrative Tribunal nor Greek court would normally venture to substitute its own opinion for the option rendered by the expert, since it would lack necessary expertise to undertake complex exercise of equation of boss or pay scale. So I would like to refer to para number 20. We are also not inclined to accept the submission of the appellant that there can be no distinction in the pay scale between the employees working at headquarters and the employees working at the institutional level. It is a matter of record that the employees working at headquarters are governed by a complete different set of rules. Even the hierarchy of the boss and the channel of promotion are different. Also, merely because any two posts at the headquarters and the institutional level have the same nomenclature would not necessarily require that the pay scale on the two posts should also be the same. In our opinion, the prescription of two different pay scales would not violate the principle of equal pay for equal work. Such action would not be arbitrary or violate Article 14, 16, and 39D of the Constitution of India. It is for the employer to categorize the post and to prescribe the duties of each post. There cannot be any straitjacket formula for holding that two posts having the same nomenclature would have to be given the same pay scale. Prescription of pay scale on particular posts is very complex exercise. It requires assessment of the nature and quality of the duties performed and the responsibilities shouldered by the incumbents on different posts. Even though the two posts may be referred to by the same name, it would not lead to the necessary inference that the posts are identical in every manner. These are matters to be assessed by expert parties like employer or the pay commission. Neither the Central Administrative Tribunal nor the court would normally venture to substitute its own opinion for the opinion rendered by the expert. The tribunal or the court would lack the necessary expertise to undertake the complex exercise of equation of both or pay scale. Para number 21. In expressing the opposite opinion, we are fortified by the observation made by this court instead of Punjab versus Surjit Singh that, yes, upon review of the large number of the judicial proceedings relating to the principle of equal pay for equal work, this court observed as follows. Undoubtedly, the doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in a court of law, but equal pay must be for equal work for equal value. The principle of equal pay for equal work has no mechanical application in every case. Article 14 permits reasonable classification based on qualities of characters of person recruited and grouped together as against those who were left out. Of course, the qualities of characteristics must have a reasonable relation to the object sought to be achieved. In service matters, merit or experience can be a proper basis for classification for the purpose of pay in order to promote efficiency in administration. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenue is also an acceptable reason for pay differentiation. And mere nomenclature designating a person as, say, a carpenter or a craftsman is not enough to come to the conclusion that he is doing the same work as another carpenter or craftsman in the regular service. The quality of work which is produced will be different. Even the nature of work assigned will be different. It is not just a comparison of physical activity. The application of the principle of equal pay for equal work requires consideration of various dimensions of a given job. The accuracy required and the dexterity that a job may entail may differ from job to job. It cannot be judged the mere volume of work. There may be qualitative difference as regard reliability and responsibility. The function may be the same, but the responsibility make a difference. Thus, normally the applicability of this principle must be left to be evaluated and determined by an expert body. These are not matters where a record can lightly interfere. Normally, a party claiming equal pay for equal work should be required to raise a dispute in this regard in any event. The government and the group that all things are equal. Thus, before any discretion can be issued by a court, the court must see that there are necessary government and there is a proof. Again, SEC 2015, volume 3, page 6, volume 3, page 653, para 30 and 31. Here, the
30
honorable
and 31.
30 and 31 product. Here also, in this matter also, the honorable apex court has held that pay scale, fixation, and revision, classification of boss, and determination of pay structure held comes within exclusive domain of executive. So may I read the part 30? Para 30. In Viwaram Kanu.
What would be on page?
30 and 31.
No. Page.
Page 653.
653.
53. SSC 2015, volume 3, page
3
653.
653.
Union of India versus TVLN Mallikarjuna Rao and 8 others. The relevant portion is para number 30 and 31.
There was some confusion regarding the.
May I read the para 30 and 31?
How does it start? Para 30?
30 is page 666. 668.
Something is wrong though. Here, from page 658, it goes to 669.
Oh, there are some Williams are printed in and some pages are missing and like that they come
Yes.
sometimes.
Because,
Other way,
just check,
other way, check.
see. Page 665, no, page 65, then it goes to 668. From page 656. I think something is wrong with this. Yes, anyway, you read.
Yeah, yeah,
You get another copy.
I'll go for other one.
No, you read that also, it's okay. Para 30 and 31.
Okay.
What does it say?
May I written?
Yes.
Para 30. In Miwaram Kanuja versus All India Institute of Medical Sciences, this court has inter alia held as follows. While considering the question of application of principle of equal pay for equal work, it has to be borne in mind that it is open to the state to classify employees on the basis of qualification, duties, and responsibilities of the post concerned. If the classification has reasonable nexus with the objective sought to be achieved, efficiency in the administration, the state would be justified in prescribing different pay scale. But if the classification doesn't stand the test of reasonable nexus and the classification is founded on real and unreasonable basis, it would be violative of Article 14 and 16 of the Constitution. Equality must be among the equals. Unequal cannot be claimed equality. Then Para 31. It was further reaffirmed in a three-judge bench judgment of this court in Shyam Babu Verma versus Union of India, wherein the court held the nature of work may be more or less the same, but the scale of pay may vary based on the academic qualification or experience which justifies classification. The principle of equal pay for equal work should not be applied in a mechanical or casual manner. Classification made by a body of experts after full study and analysis of the work should not be made to be unreasonable. Inequality of the mean in different groups exclude applicability of the principle of equal pay for equal work to them. The principle of equal pay for equal work has been examined in the state of MP versus Pramod Prateria. It was held in the ACC 1993, Volume 1, 539. By this court, before any direction is issued by the court, the claimant have to be established that there was no reasonable basis to treat them separately in matters of payment of wages or salary. Then only it can be held that there has been a discrimination within the meaning of Article 14 of the Constitution of India. I would like to refer to another SSE, which reported in 2002, Volume 4, SSE 556.
Yes. Para.
Para 16, 17, and 20. Here the parties are stepping up India versus M.R. Ganesh Babu and others.
Yes.
Para 16. The principle of equal pay for equal work has been considered and applied in many reported decisions of this court. The principle has been adequately explained and crystallized and sufficiently reiterated in a cabinet of decision of this court. It is well settled that equal pay must be depend on the nature of work done. You cannot be judged by the mere volume of work. There may be qualitative difference as regards reliability and responsibility. Function may be the same, but the responsibility make a difference. One cannot deny that often difference is a matter of degree and that there is an element of value judgment by those who are charged with the administration and fixing the scale of pay and other condition of service. So long as such value judgment is made bona fide, the reasonable and an intelligible criterion which has a rational nexus with the object of differentiation, such differentiation will not amount to discrimination. The principle is not always easy to apply as there are inherent difficulties in comparing and evaluating the work done by different persons in different organizations or even in the same organization. The differentiation in pay scale of person holding same posts and performing similar work on the basis of the difference in the degree of responsibility, reliability, and confidentiality would be a valid differentiation. The judgment of administrative authority concerning the responsibilities which attach to the post and the degree or reliability expected of an incumbent would be a value judgment of the authorities concerned, which, if arrived at a bona fide, the reasonably and rationally was not open to interference by the court. Paragraph 17. Since the play of equal pay for equal work has to be examined with reference to Article 14, the burden is upon the petitioner to establish the right to equal pay or the play of discrimination as the case may be. First of all, I may be allowed to refer another decision given by the Honorable Apex Court, which was reported in 2002. 2002, Volume 6, SSE 72. The State of Haryana versus Haryana Civil Secretary Personal Staff Association. Here also referring to the fixation of pay and determination of parity in duties and responsibility is a complex matter which is for the executive to discharge. So I may be allowed to refer paragraph 10 only. Paragraph 10. It is to be kept in mind that a claim of equal pay for equal work is not a fundamental right vested in any employee, though it is a constitutional call to be achieved by the government. Fixation of pay and determination of parity in duties and responsibility is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors, some of which have been noted by this court in the decided cases, are to be considered, keeping in view the prevailing financial position and capacity of the state government to bear the additional liability of a revised scale of pay. It is also to be kept in mind that the priority given to different type of boss under the prevailing policies of the state government is also a relevant factors for which for consideration by the state government. In the context of the complex nature of issues involved, the far-reaching consequences of a far-reaching decision in the matter and its impact on the administration of the state government, court have taken the view that ordinarily courts should not try to delve into administrative decision pertaining to pay fixation and pay parity. That is not to say that the matter is not justifiable or that the court cannot entertain any proceeding against such administrative decision taken by the government. the courts should approach such matters with restraint and indiffer only when they are satisfied that the decision of the government is patently irrational, unjust, and prejudicial to a section of employees, and the government, while taking the decision, has ignored factors which are material and relevant for a decision in the matter. Even in a case where the court holds the order passed by the government to be unsustainable, then ordinarily a direction should be given to the state government or authority taking the decision to reconsider the matter and pass a proper order. The court should avoid giving a declaration, granting a particular scale of pay, and compelling the government to implement the same. As noted earlier in the present case, the High Court has not even made any attempt to compare the nature of duties and responsibilities of the two sections of employees, and one in the State Secretariat and the other in the Central Secretariat. It has also ignored the basic principle that there are certain rules, regulation, and executive instruction issued by the employers which govern the administration of the cadre. Lastly, there's also SSC which was reported in 2024. SCC online, Jammu and Kashmir, 149. Shaktish Kumar and others versus State of Jammu and Kashmir. This is regarding the post of data operator, computer operator in the Department of the State Pollution Control Board. They are given the grade 950 to 1500, whereas Agri Department, Forest Department, and the High Court of Jammu and Kashmir, they have given grade 1400 to 2300. So the employee of the State Pollution Board, they have approached the Honorable Court that they as claimed by the petitioner in the present case. Now, my lord, in my here in this, I would like to rely on the paragraph 6, 7, 8, 11, 12.
7, 8, 11, 12. 6, 7, 8, 11, 12.
12. May I read? This is the last reference. Paragraph 6. It is being further stated by the petitioner that upon coming to know about the aforesaid disparity in the pay scale in the post in question held by them and the equivalent post in the Agriculture Department, Forest Department, and the High Court, representation came to be submitted by them to the Chairman State Pollution Control Board on 9/2/2000 for removal of the pay anomaly and the discrimination, which representation was not responded to, necessitating the filing of the instant petition. 6. Paragraph 7. Objection. Objection to the petition have been filed by the respondent wherein it is being inter alia stated that the post of data operators carrying the pay scale of 950 to 1500 pre-revised. In the respondent number 2, board came to be filled up after a process of selection was undertaken by the board, and the petitioners, after participating in the process of selection conducted by board, came to be selected and consequently appointed against the boss in question carrying the grade 950 to 1500. Paragraph 8. It is being further stated that the boss in question, that is post of data operator in the board carrying pay scale 950 to 1500 is distinct and different in nature. Nomenclature and workload from the post referred by the petitioners in other department, and as such, the petitioner have no claim which can be entertained. Paragraph 11. Having regard to the aforesaid principle and proposition of law and referring back to the case in hand, the petitioner herein for the purpose of seeking parity of scale of pay in the case have referred to and relied upon the employees working in the Jammu and Kashmir Forest Department in the High Court of Jammu and Kashmir and also in Agriculture Department besides a similar post advertised in advertisement notice number 3 of 1996. A deeper and closer examination of the plea and documents supporting the said plea relied upon the petitioner would manifestly show that the parity is being sought for advertisement notice number 3 of 1996 for the boss of computer assistant in fishery department as also the boss of computer analyst in the same department and the boss of computer operator in forest protection force besides placing reliance on a later claim to happen at trees by the Director of Agriculture to Deputy Registrar, High Court of Jammu and Kashmir, dated 26/4/1997, pertaining to the boss of computer operating carrying pay scale of 1400 to 2300, as also a later dated 28/4/1997, at trees to the Principal Chief Conservator of Forest to the Deputy Registrar Computer, High Court of Jammu and Kashmir, reflecting therein the grade attached to the boss of computer operator as 950 to 1400. A reference has also been made for the purpose of the claim of the petitioner on the advertisement notice number 3 of 1997. Also, pursuant to which the petitioners came to be appointed for the boss of data entry operator in the finance department, carrying the grade of 1200 to 2040 per job. The petitioner, though, in order to buttress their claim, have referred to the aforesaid facts and the documents, yet failed to show that aforesaid posts they are appointed against and the posts with which the petitioner are seeking parity are the same and similar in regard to the function, responsibility, reliability, and confidentiality. A general plea raised by the petitioner for invoking the principle of equal pay for equal work without even remotely showing the applicability of the principle laid down by the apex court in judgment supra cannot be entertained. The claim of the petitioner seemingly is misconceived and legally unsustainable. So that is my humble submission before the court. So why the state has would not accommodate all the employees of the village card. So that is the principle behind the decision of the state government. So that is my submission before the honorable court.
Any reply?
My lord, just in addition to what has been submitted yesterday, just this morning, the petitioners, a writ petition by way of the PPC 110 of 2025 has been filed just this morning and was moved, wherein the petitioners whose rank falls in the who falls in the rank of Sepoy, Lance Naik, Havildar, and Havildar Major, whose services are voluntary in nature. So they have also moved this morning seeking minimal pay scale. Therefore, Lordship, if this honorable court come to a conclusion that the rank of Jamatar is equivalent to that of the constable in the police, then it may have a huge impact on that case.
Earlier, the village card association of Nagaland, they filed a petition, and that honorable court they have recommended to consider the expert committee and to determine the existing scale of the village card. And after that, the expert committee constituted and they referred to the Ministry of Home. So after that, there was a dispute whether the state respondent has violated the direction of our court. Contempt was proceeded for such a long period, but last year, contempt was disposed that there was no violation and there was no disobedience of the honorable court. So by that recommendation of the expert committee, as per the direction of the honorable court in the disposal of WBC, now petitioner has come forward. The same association come forward and they file a repetition claiming that the recommendation of the expert committee. So both the cases are more or less connected.
Then you should have told the court from the very beginning. We could have clubbed it up together then.
Yes.
Because if we pass
Yes,
order in this
yeah,
case,
coordinated bench, no?
Ah.
So, yeah, so there are some difficulties, whether we have to wait or,
exactly,
yeah, we have to work it out.
My lord, in this regard, if a short date may be fixed, so that I need to consult my senior on how to go about this.
the problem is we have already heard almost everything.
Yes.
Now only reply is awaited. We will keep it part heard then.
Just on this, on that issue, if,
When?
this week, will be okay this week. This week. This week, yeah.
This week, I have applied for leave from Thursday. I'll be in the principal bench Thursday and Friday.
Because this court is not sitting when the vacation reopens. So if I keep part heard again, it don't come up.
But we can just wait also. Because definitely the lordship will come again
August
by virtue of
first week.
the, well, considering the circumstances at this juncture.
Okay.
As and when the
Hmm.
this bench constituted, we can
Learned
carry forward also.
counsel- Learned counsel for the state, learned additional AG, Mr. N. Timson for the state of Nagaland. So at this juncture, the learned counsel for the petitioner has submitted that another writ petition
By
has
way of
been filed
WPC,
by way of WPC
110 of 2025,
110 of 2025 by the
by those in the rank of Siboy.
Village
Next,
Guard
village
Association of
guard.
by
Nagaland.
the Village Guard Association of Nagaland.
Yes.
Which may have a bearing on this case. And therefore, the learned counsel for the petitioner would like some time to clarify
Yes.
the said matter. Listed in the first week of August, then first week of August, and as part heard.
Right, my lord.
And this is also a testing. Spend a lot of time.
This one's photocopy.